A three-judge bench of Supreme Court, wide order dated 20th February 2024, directed that specially petitions in Gayatri Balaswamy versus ISG NOVASOFT Technology Limited be placed before Chief Justice of India for an appropriate order. The fulcrum of the legal controversy in this case rests on the following questions. Are Indian courts jurisdictionally empowered to modify an arbitral award? If so, to what extent? The controversy arises because Arbitration and Conciliation Act 1996 does not expressly empower courts to modify or vary an arbitral award. Section 34 of 1996 Act only confers upon courts the power to set aside an award. Nevertheless, the court on several instances has been compelled to modify arbitral awards seeking to minimize protracted litigation and foster the ends of justice. In contrast, some judgments have posited that Indian courts cannot modify awards due to narrowly defined scope of Section 34. Therefore, divergent and contrasting judicial opinions exist on this question. The reference was answered today on the following terms. As set out in the body of the judgment, while exercising power under Section 34 of Arbitration and Conciliation Act, and consequently the courts in appellate hierarchy do not have the power to modify the arbitral award. Modification and severance are two different concepts. While modification is not permitted under Section 34, severance of the word following fall of Section 34 is permissible in exercise of powers under Section 34. Such a power of severance is also available to courts in the appellate hierarchy to Section 34. The power to set aside will not include the power to modify, since the power to modify is not a lesser power subsumed in the power to set aside, and as held, the power to set aside and power to modify do not emanate from the same genus and are qualitatively different powers in context of Arbitration and Conciliation Act. The judgment in Hakim case, insofar as it holds that Section 34 court has no power to modify the award, it lays down the correct law. The only exception made in this judgment is with regard to the power to carry out corrections in computational errors, clerical errors, or typographical errors, and any other errors of similar nature. This is based on the principle of actus curiae neminem gravebit. Act of court shall prejudice no one.